You've probably heard this one before. Just move the properties into an out-of-state LLC. It's much safer. But when clients bring that to me, it is almost always because they have watched the video or worse, got advice from someone who's never had to deal with how California law actually applies when something does go wrong. I'm Ali Talai, a California asset protection attorney, and I have seen firsthand how this strategy backfires. And in this video, I will walk you through why that advice is legally flawed, what judges actually look for, and how to structure your LLCs the right way so you can protect your property, avoid litigation headaches, and stop building your strategy on advice that only sounds smart. All right, so let's get right down to it. There is a lot of bad advice floating around online about asset protection, and one of the most common is the idea that you should move California real estate directly into an out-of-state LLC like Wyoming, Nevada, or Delaware. And suddenly, everything is safe. The problem isn't that the out-of-state entities never have a role. The problem is that this advice is usually incomplete, misunderstood, and properly executed, especially when California real estate is involved. When people follow it blindly, it often backfires. All right, so let's talk about what California courts actually care about, where this strategy goes wrong, and how to structure things in a way that actually holds up when tested. If an LLC owns California real property, collects rent here, or operates here, California considers that entity to be doing business in California, regardless of where the LLC was formed. That means an out-of-state LLC that directly owns California real estate must register as a foreign LLC in California, file statements of information in California, pay California's annual franchise tax. Forming the LLC elsewhere does not avoid that obligation. Skipping registration of the company in California does not create some sort of protection, it creates problems. Unregistered LLCs can face penalties, back taxes, and interest, and they may lack the legal capacity to enforce their own rights in California courts. I have seen landlords unable to move forward with an eviction until they first clean up years of non-compliance, and failing to register doesn't keep you off the radar. If a tenant or a third party sues, courts allow alternative service methods, and the lack of registered agent often gives the plaintiffs more leverage, not less. More importantly, and this is the key point that aligns with the charging order discussion, California controls property level liability. If a tenant is injured in Los Angeles, the lawsuit will be filed in a California court, Los Angeles court, and California law will govern liability, damages, and remedies tied to that property. Filing paperwork in Wyoming does not change that. This is why moving California property directly into an out-of-state LLC does not remove you from California's legal system and can actually make things worse if it is done incorrectly. And here's the irony. Trying to save $800 by skipping California registration usually ends up costing you far more, especially when you need to evict the tenant or defend the lawsuit. Another myth is that forming an LLC in a strong state somehow makes you invisible to California lawsuits. It doesn't. If the conduct, the asset, the harm, and the people involved are all in California, a California court will apply California law, period. Judges don't care where the LLC was formed when they are deciding liabilities for injuries tied to California real estate. And if you are personally involved in managing the property, as landlords are all the time or most of the times, you will often be named personally in the lawsuit along with your LLC. An LLC does not erase personal liabilities for your own conduct. This is why asset protection is not about avoiding lawsuits. It's about controlling what assets are exposed when a lawsuit happens. And this is where people get confused. Out-of-state LLCs don't protect you from California property liability, but they can play a role at the ownership level when structured correctly to help protect assets that had nothing to do with the lawsuit. That's very different from simply moving a California property into a Wyoming LLC and hoping for the best. Another area where online advice tends to oversimplify things is that you get to hear that transferring California real estate into an LLC automatically triggers reassessments, transfer taxes, or other penalties. That is not how California property tax law actually works. California follows a proportional ownership rule. If real property is transferred into an LLC and the owners retain the same proportionate interest before and after the transfer, that transaction is generally not considered to be a change in ownership for property tax purposes. In many cases, these transfers are treated as gifts or contribution, not sale, and they typically do not trigger any transfer tax either. Where people get into trouble is not the concept, it's the execution of it. Reassessment typically happens when transfer documents are prepared incorrectly, ownership percentages are unclear, or required supporting documents like the operating agreements are missing or inconsistent. I see this most often when deeds are prepared by someone who isn't familiar with California's property tax rules. Even then, a reassessment is not always the end of the story. California law provides remedies. Improper reassessments can often be appealed, corrected, or reversed once the proper documentation is provided and the proportional ownership is clarified. The key takeaway is this: transferring property into an LLC does not inherently create tax problems, but doing it without California's specific knowledge absolutely can. Some out-of-state LLCs are often marketed as providing instant anonymity, and that is an oversimplification. When California real estate is involved, no structure makes you completely invincible. But that doesn't mean that we cannot do some privacy planning and that the privacy planning is pointless. That is absolutely not what I'm saying. Is that it makes it more difficult, and you got to know the nuances to make sure that you do the privacy planning the right way. It's true that a foreign LLC owning California property must register in California, but how that registration is handled makes a real difference. When it's structured correctly, the public filings do not need to point directly back to the individual owner. For example, the LLC's address does not need to be the personal residence or business location of the client. A properly established commercial mailing address can be used instead. The registered agent does not need to be the owner, and when the statement of information requires disclosure of ownership or management, that disclosure can often list an entity such as another LLC or even a trust rather than naming the person individually. And by doing that, we could truly create some privacy planning. When this thing is done correctly, it is not going to make it impossible for somebody to trace you, but it will make it much more harder. And that is the real goal of asset protection and privacy planning, not secrecy, but creating distance, friction, and leverage. In litigation, a determined attorney obviously can subpoena documents. That's the reality, but layered privacy planning reduces casual discovery, discourages fishing expeditions, and puts the property owner in a meaningfully stronger position than if everything were held in their personal name. Privacy is not achieved with a single out-of-state LLC. It is achieved through intentional structuring, clean documentation, and multiple coordinated layers that work together. States like Wyoming and Nevada do offer stronger charging order statutes at the ownership level. This matters when a creditor is trying to reach your membership interest because of a personal lawsuit, like a car accident. But when an out-of-state LLC directly owns California real estate, California courts can and still apply California remedies when enforcing judgments tied to California assets. This is why relying on a single out-of-state LLC to own your California property is not the same as layered structures. Out-of-state entities can add protection when used above the operating entity, not as the replacement for it. Here's the framework that is consistent across all my videos. California real estate should be usually operated through a California LLC. That aligns the entity with the law governing property and avoids unnecessary compliance problems. Where out-of-state LLCs can play a meaningful role is at the ownership level. For example, when a Wyoming LLC owns the California operating LLC, in that structure, California law governs the property, but the Wyoming law may govern remedies against ownership interest if the owner is sued personally. That layering approach creates friction, delays, and leverage, especially when paired with a properly drafted operating agreement that restricts transfers, distributions, and control. Insurance remains the first line of defense, entity structuring is the containment layer, and trust planning often become the outer layer for long-term protection. No single entity is a magic shield. Asset protection works when the layers are intentional and coordinated. So the takeaway is simple. Moving California property directly into an out-of-state LLC is often misunderstood and oversold. It does not remove California law. It doesn't make you invisible, and it can create problems if done incorrectly. If you're a California business owner or rental property investor, you need to know how to protect everything you have built, not just from lawsuits, but also from probate, taxes, and other risks. That is why in my next video, I am covering estate planning for California entrepreneurs, 5 documents you must have. You don't want to miss this if you want to save your family and your business from disaster. I look forward to seeing you over there.